exposures they have. And by way of introduction, I want to introduce you to a concept called the coverage wall. When we get an injured employee, in most states you've got state workers' compensation to start with, but there are a number of other remedies available to them. And unfortunately, we're not in the position that we can tell the injured employee, or for that matter their attorney, how to bring the claim. So what I'd like to suggest is we look at this coverage wall as a method of building the right bricks in place so that whatever way the claimant or their attorney files the claim, we have that wall in place to respond. The starting point of this is state workers' compensation. It's the foundation to every policy in every state. It's mandated, of course, in everywhere except Texas and in a strange way New Jersey. But it's essential not only to provide that basic state workers' comp, but also to protect some of the longshore exclusions, which we'll look at a little bit later. Our first tower, our left-hand tower here, is our federal and international coverages. The first one is the Outer Continental Shelf Lands Act. For those of you listening in from areas down in the Gulf of Mexico, you'll probably be pretty familiar with this. It's pretty essential for many businesses in those areas. But for those of you from the coast or from the center of the country, this may be a little more mysterious. Simplistically, all it does is takes longshore and extends it into the outer continental shelf. Longshore typically stops at 12 miles, and the outer continental shelf simply expands that beyond the 12 miles out to the outer edge of the outer continental shelf. Federal Coal Mine Health and Safety Act, again, that's pretty obvious. It's going to cover coal mine health and safety. Not, again, an issue down here in Florida, but if you have some of you up in the Virginias or maybe Western Pennsylvania, that may be more of an issue. Federal Employers Liability Act, obviously that's federal government employees. Our Defense Base Act, again, we're not going to spend any time on that today, but a huge subject in its own right. The Defense Base Act covers most of the contractors working in the Middle East and for the U.S. government on foreign defense bases across the world. The Non-Appropriated Funds Instrumentalities Act is a coverage for the private workers working on U.S. defense bases. And here people are not paid by the federal government. They're paid by their own generation of income. So, for example, somebody working in a golf course on a Air Force base, which we happen to have one here in Tampa, their money and their revenues generated from the fees. That is a non-appropriated funds, and people on there get a separate type of workers' comp. And last, in our left-hand tower, we have the international issues. Obviously, people traveling overseas, outside of DBA, will need international coverage in some format. Our right-hand tower is our marine employees. Protection and indemnity and maritime employers liability. We'll talk more about those later, the difference between the two and exactly what those cover at the end, towards the end of this hour. And last, my keystone is the Longshore and Harbour Workers Compensation Act. That's where we're going to spend a fair bit of the time today, identifying the people that are covered by it and who's not covered by it, and how to properly cover it. This is the key to the whole thing. If we put this in place for our waterfront employees, we have that brick wall which can be fired at by any claimant or their attorney. So why do we care? Well, simplistically, on a countrywide basis, a state act claim of a minor injury might cost us $10,000. If we turn that into a longshore claim, that typically more than doubles, something like 2.5 on a national level.
Welcome to Go-To Training, online training made easy. There are 146 other callers on the call.
It's at a bus stop. Injured on a shipyard or dock, call so-and-so law centre, PA. There's another one out there called 1-800-C-SICK. So there's people out there, attorneys out there, really pushing for this because of the increased benefits and the increased fees they can derive from these benefits. Here's the big problem, though. We're sitting here in November talking about a policy you might put in force next year. Excuse me. That policy might have a claim towards the end of next year, which might not come to trial for 3 or 4 years down the road. The problem is we're tested on what's happening at the time that goes to trial, not on the time we make this recommendation. The case law is constantly expanding both longshore and admiralty. So if you can find somebody that's on the borderline today, the probability is by next year or the year after, they're going to be included in these coverages, and that's the time we have to deal with it. Workers' compensation law means the workers' or workmen's compensation law or occupational disease law of each state or territory named in 3I of the information page, 3A of the information page. It includes any amendments to that law which are in effect during the policy period. It does not include any federal workers' or workmen's compensation law, any federal occupational disease law, or the provisions of any law that provide non-occupational disease benefits, disability benefits. This is straight out of the NCCI policy wording. And what this says is that the workers' comp policy in its unendorsed mode covers no longshore benefits or any of the other federal workers' or workmen's compensation benefits. There are, in fact, 2 different types of states in this country. One what they call single jurisdiction, and the other one they call dual jurisdiction or concurrent jurisdiction. And yes, this is the workers' comp policy wording for the question that just popped up. Those that are in single jurisdiction states are only entitled to workers' compensation or longshore. There is no overlap between the two. And we actually have a court case that proves that an insurance company who writes a state act workers' comp policy without a longshore endorsement owes not only no payment to an injured employee, but also no defense to them, to their employer. In a concurrent jurisdiction, and California is probably one of the best examples of this, what happens is the state policy pays up to the state limits, and then the longshore policy just goes as a supplemental, adds the additional benefits. But clearly, if you've got somebody in longshore in a single jurisdiction state that has no insurance, getting no benefits is going to send them running to the attorney very quickly. So what I'd like to do now is move and look at the Longshore and Harbour Workers' Compensation Act. This was originally enacted in 1927 and was designed to cover just shipyard workers and a few people like that. What's happened, unfortunately, is since 1927 it's expanded drastically, so it includes a whole bunch of different employees and types of employment that you wouldn't think possible. And I hope over the next 15 minutes or so to show you how broad that can be. To gain longshore benefits, you have to qualify in 2 ways. They're called status and situs. These are the fancy legal terms, but status is simplistically, what type of job am I in? I'm in the right type of job. And situs is, where did the accident happen? If you fail status, you don't need to do situs because you're out. If you fail situs, you don't need to work on status because you're out. You have to have both to get longshore benefits. I tend to do the situs test first. I just find that a little easier. It doesn't really matter which way round you do them. It just matters that you do them, and you do them separately. When you try and blend the two together, it can get very confusing. We're going to look at status first, which is what type of employee am I? The term employee means any person engaged in maritime employment, including any longshoreman or other person engaged in longshoring operations, and any harbour worker, including ship repairman, shipbuilder, and shipbreaker. This is straight out of the Longshore Act. It's the definition of an employee, and it sets up the status. Anybody, any longshoreman, somebody loading and unloading a vessel, anybody loading and unloading a vessel, a harbour worker, a ship repairman, a shipbuilder, and a shipbreaker is like a junkyard for ships. They're pretty obvious ones. But if you go a little further and think about this, anybody loading and unloading a vessel, that could be a very broad term. You might have a plumber, let's say, that gets a job to go out to an island. And in the process of doing that job on the island, he loads onto a boat of some variety a new sink or a new bath to take out with him. They're loading a vessel, and they become a longshoreman by just doing that job. Courts so far haven't extended it to just loading your own tools as a workman, but as soon as you start loading product onto the vessel, you become a longshoreman. Now we've got 8 exclusions to look at, and these are the people that we'll really take out of longshore. So it's really anybody else that's in any type of maritime employment except these next 8 exclusions. The first one is individuals employed exclusively to perform office clerical, secretarial, security, or data processing work. We had a question from one of the attendees earlier on about a computer programming service. Now, it does fall under data processing if they just perform software work, but the moment they do hardware work, in other words networking, which most of them do today, they lose their exclusion and become longshore. Clerical employees have to do it exclusively within the office. If they venture out of the office, they are no longer considered clerical for the purpose of the Longshore Act, and are therefore longshoremen. One of the classic examples of this was a bookkeeper who worked in a shipyard. She thought that she was exempt from longshore, went down to the warehouse to collect some invoices off a packing crate. She fell when she was in the warehouse, and she was adjudicated to be longshore because she was no longer in the office environment. A recent case even took security guards and limited that to the office. I'm not sure I totally agree that the security wording here should be prefaced by office, but unfortunately the courts do. And they said that the only security guards that are now excluded from longshore are those that work exclusively in the office. Frankly, in a shipyard, if you've got a security guard that works only in the office, they're not really doing their job. They need to be out going around and patrolling. I think one of the greatest examples of this one to me was a young lady whose job it was to check you in for a cruise line. If those of you who've been on a cruise, you know you go to a front desk. It looks just like a hotel front desk. You go there, they give over your credit card, probably some ID, and they give you a thing called an A card. It works exactly like it does in a hotel with your room card, except it usually has your photograph on there, this A card. The courts ruled that this lady was a clerical employee, but she was not office clerical. And they ignored, to my opinion, the letter of the law here and said, you're not office clerical because we don't believe people will go on cruise ships without you being there and doing your job. Therefore, you're going to be essential to the cruise ship industry, therefore you're longshore. This is an ever narrowing exclusion. The next exclusion is individuals employed by a club, camp, restaurant, museum, recreational operation, or retail outlet. A museum would include an aquarium. A club will be a non-profit type of club, like a yacht club or a boat club. A camp will be a Boy Scout camp, a summer camp, anybody in that type of arrangement. Recreational operations will include the beach rentals, if you go around and rent a deck chair or maybe a pedalo bike. A retail outlet is a store that doesn't sell parts for vessels. It has to be more of a general store. It could be shoes, it could be t-shirts, but not vessel parts here. We may get them out elsewhere. One of the interesting ones in this particular exclusion is the word restaurant. Restaurant employees are excluded from longshore, but there is no exclusion for catering. So if you go on a party boat and you attend, let's say, a holiday party on a boat, a restaurant comes on and does the catering for it, they're excluded. But a catering company, which in many ways is very similar to a restaurant, comes along, then they're not excluded and they're longshoremen. In fact, that party boat might even have the vessel crew do the catering. In that case, they will be considered admiralty coverage. We'll get to that a little later. Exclusion C are individuals employed by a marina. Now, there's a word really missing out of the Act here, and they talk about individuals employed directly by a marina when you talk to the Longshore Division about this. What they're saying here is they don't consider subcontractors part of this exclusion. They'll come along later on. But the next question really is, what's a marina? Now, we can go to Scopes and find out a definition of a marina from Scopes, but that doesn't apply here. A marina is a place in the eyes of Longshore that gets excuse me, that gets their majority of their income from the storage of recreational boats. They can do incidental repair, they can do storage on land, in water, in racks, doesn't matter. But most of their revenue must come from storage. And as you see in the exclusion, they can't engage in construction, replacement or expansion of the marina other than routine maintenance. If they fit that definition, it doesn't matter what size or type of boat is in that marina, they're excluded. We'll get an exclusion later on for some boat yards and which deals with some type and size, but so far they're not included here. This is only a marina. Exclusion D is, according to the federal government, the most frequently requested and rarest granted exclusions. They're employers, transporters or vendors who are temporarily on a marine site and are not engaged in their normal work of that employer. This is designed for the soft drink salesman. Comes along, drops their product on the dock, leaves again. Nice and easy, doesn't go on board the vessel. Problem is that rarely happens. If they start wheeling their product up the gangplank to put it on the vessel, then they suddenly become the stevedores because they're loading and unloading a vessel, and they get the longshore benefits. If they go on board to repair a broken vending machine, unfortunately this is one of my claims, the vending machine wasn't attached to the bulkhead and fell over and squashed the person, they were a ship repairer because they're repairing the ship. I think the broadest interpretation of this by the Department of Labor was a pest control service. They were going on to cruise ships and spraying for little furry things running around on the cruise ships. The Department of Labor, in their wisdom in this particular case, said, okay, you're a vendor, you're selling pest control services. You're certainly temporarily on the port situs, and pest control is not the business of the cruise line. But we don't think people would cruise if there were lots of little furry things running around. Therefore, you're essential to the cruise ship industry. Therefore, you're longshore. And again, I think they ignored the letter of the law and created a decision that incorporated these pest control people, even though the Act doesn't really contemplate that. Exclusion E is aquacultural workers, they're fish farmers. If you're fish farming, you throw some fish into a pen or a pond or a fenced-in area, you're considered an aquacultural worker and you're out of longshore. However, if you go out into the bay, throw some clams down, come back 6 months later to collect them, you are a longshoreman. That aquacultural has been defined not to include free work in the water. It has to be in a controlled environment. Exclusion F changed in 2009. Part of a group that organized this change took about 10 years to come into place to include some recreational vessels. I want to read you this exclusion, and then I've got a little chart on the next slide which I think will explain it better. Individuals employed to build, repair, or dismantle any recreational vessel under 65 foot in length, or individuals employed to repair any recreational vessel or to dismantle any part of a recreational vessel in connection with the repair of the vessel. This works for boat yards, it works for subcontractors, it works for any independent groups that work within the marine environment. First, you need to look at what type of vessel they're working on. Are they working on recreational vessels under 65 foot, recreational vessels over 65 foot, or commercial vessels? If they touch any commercial vessels, they're longshore. We don't have to go any further. Let's move on. If they strictly stay under 65 foot and recreational, they're state act. But if they're over 65 foot and recreational, they're longshore if they build, construct, or manufacture the vessel, and that includes finishing out the vessel. But they're state if they repair or service. That yellow box is the one that changed in 2009. Other than that, all the other five boxes remain unchanged. The important point here is, what is a commercial vessel? It's easy to think of a ship or a ferry boat as being a commercial vessel, but a charter boat, a sheriff's boat, a patrol boat, a towboat, they're all commercial vessels as well. And so anybody working on those will fall under that last line and be longshore. If individuals are described in clauses A through F are subject to coverage under a state workers' comp law. This is the catch-all for the marine industries. What this says is, to be eligible for any of those exclusions, there has to be a state workers' comp policy in force and benefits available to that person. Texas, this becomes particularly important there, but we also have the same issue in Florida for small businesses. If your state doesn't require you to buy a state workers' compensation policy, and you don't, you still lose the exclusionary language under the Longshore Act, and it pushes you into longshore. So any marine business in any state, regardless of size, needs a state act policy at the very minimum. And that includes the marinas and the small artisans contractors. Two more exclusions are admiralty exclusions, the master and member of a crew of a vessel, or any person engaged by a master to load or unload or repair any small vessel under 18 tons net. That's very rarely used. It has to be employed directly by the master or a member of the crew. They can't be employed by somebody in the middle. They have to be employed directly by the vessel, and it's only for a small vessel, 18 tons or so. But these two people would be considered a member of the crew, and they would get admiralty benefits. If you print out your outline, you'll find that this list is now about 80 people. I've just included the top 20 or so on the screen here. If we go back a couple of minutes, we talked about the 5 major classes of business that are covered under longshore. The only reason I've included this list is to show you that the Longshore Act has expanded so drastically that from 5 basic occupations in 1927, it's gone to close to 100. Now, this doesn't mean that every person on this list is always a longshoreman, and it certainly doesn't imply if you're not on the list you can't be a longshoreman. This is simply a summary of some cases where they have satisfied the status test in certain cases. I think one of the best ones is a fish processor. A fish spotter. He was an aeroplane pilot. Ran out, found the fish, told the fleet where to go, and he was held to be longshore. Even though he never touched the water, he was well above it. I'm going to catch up a couple of questions we have for here, which I think are relevant to this. If the repair work is done on a recreational vessel while it's on the water, again, if you fail the status test, the type of job, so if you're repairing a recreational vessel, you're out of longshore. Second one, marina workers that may work to repair on a 6-pack charter boat. Again, if it qualifies as a marina, then it doesn't matter what type of boat they work on. The security guard is on the status test just because that's the way the law was written and adapted in 1972. Again, it's been interpreted to only mean office-based security guard. And lastly, the 18-ton commercial threshold is only for that one last exclusion, casual labor hired to help load or unload the vessel. It doesn't apply to any of the others. Let's talk about the situs now a little bit. Where did the accident happen? And the law says, except as otherwise provided in this section, compensation shall be payable under this Act in respect of disability or death of the employee, but only if the disability or death results in injury occurring upon the navigable waters of the United States. There's no simple definition of navigable waters, so we have to take a number of court cases and put them together. And you're going to hear Ian's definition now, which is a quick summary of those court cases. It's a waterway in which you can directly or indirectly travel to another state, country, Gulf of Mexico, or ocean, even if it's not currently navigable. And it also goes out to 12 nautical miles limits. 12 miles offshore. Nautical miles about 1.1 land miles, about 13.5. If you look at the Coast Guard, they're going to go around and talk about Coast Guard waters as being navigable. And certainly if you're in navigable waters insofar as Coast Guard's concerned, then you're going to be under longshore. But unfortunately, longshore waterways go a lot further than that. Here's the question. Can you directly or indirectly travel to another state, country, Gulf of Mexico, or ocean? So if we consider things like the Mississippi, the Ohio rivers, clearly we can do that. There's no question about that. We can go through locks maybe, that's okay. But in their own right, they border two states, and so it makes them navigable in many cases. Lake Okeechobee sits right in the middle of Florida in the Everglades. There's the intercoastal waterway travels straight through it. The Everglades flow in and out of Lake Okeechobee. From Lake Okeechobee, you can simply get to the Gulf of Mexico or to the Atlantic Ocean. One of the ones people struggle with the most will be like a place like Lake Tahoe. Lake Tahoe is a landlocked lake. It's 100% landlocked. There are no rivers that run in or out of Lake Tahoe that go anywhere. However, on one side it's Nevada and the other side it's California. So you can travel between two states. If you put in your mind for a moment a picture of the United States and all the various state boundaries, the vast majority of these state boundaries are squiggly lines. And they're squiggly lines because they're rivers. They might be dried up, they might be frozen, they might be silted, but each one of those rivers allows you to travel between one state and another. That makes it navigable waters of the United States. So what's not navigable waters of the United States? It's a landlocked lake upstream of a dam on a river with no locks to bypass, all within a single state. I think one of the best examples of this is if you come to Disney World up here in Orlando, you can go on board a paddle steamer and go across a lake called Lake Buena Vista. That is a 100% landlocked lake. There are no rivers that run in or out of it. That is not a longshore location. And anybody working there will be a State Act employee. They would not be in a longshore situs. Unfortunately, the law doesn't stop there. The slide you're looking at now is missing some words, unfortunately. But what it says at the bottom is including any adjoining area. So we don't have to be just on the water for longshore. We can be in an adjoining or area next door. A couple of court cases we're going to show you here give you some ideas of what that next door means. The first one is called Northwest Marine versus Caputo. When you take a container off a ship and take it away from the vessel and take the product out of it, it's called stripping. It's stripping the product out. And what the court said is, look, a container is now the modern of a ship's equivalent of a ship's hold, so stripping a container away from the vessel's edge is now a longshore situs. Subsequent to that, a case called Brady Hamilton versus Heron set up the 4 tests that the courts use for longshore situs. 1, was the site suitable for maritime uses? 2, how close was the waterway? 3, what was the proximity of the, I'm sorry, I already said that one, adjoining premises used in maritime commerce? And is as close to the water as feasible? The cases on this get pretty broad, and in fact the broadest one of the lot is one called Gilliam versus Bath Ironworks. Bath Ironworks is in Maine. It's just off of 95. If you go north in Maine, it's probably covered with snow right now, but it's a very major ironworks shipyard and built naval vessels for a long time. They put a steel fabricating plant 4 miles inland from the shipyard. All it did was made steel plates that were used in the building and repair of ships. The court said there's an inseparable functional interrelationship between the 2 facilities. In other words, this is one single shipbuilding unit, and they therefore held that it was situs. The courts so far have not taken that for mixed-use facilities. So if this fabricating plant made some steel plates for, let's say, bridge building, and also made some steel plates for the shipyard, the courts so far haven't considered it to be an adjoining area. But it was as close to the water as feasible because there was nowhere else between the shipyard and this location where they could load the plant, create these steel fabricating plant. Section 4A says every employer shall be liable for the compensation of payment of compensation. If an employer is a subcontractor, if they fail to secure the payment of compensation, the contractor may be liable for compensation. In other words, there's a direct pass-up of benefits here. There is no independent subcontractor rule in longshore. Either you're covered or you're not covered, and if you're not covered, you're covered by the person that hired you. This can get really interesting because you might have a situation where a subcontractor would not be exempt from longshore, but their principal might. For example, if we have a marina where the employee is a subcontractor that has a subcontractor, the marina employees themselves will be excluded, but the subcontractor might not. If that subcontractor didn't have any longshore insurance, that would pass up to the marina to pay the claim, regardless of the fact they may not have any longshore exposure themselves. We also have a very strict list of who is approved. And at the end of this presentation, I've got some links for you that you can either write down or print out of your outline. And one of the links is to this list of approved carriers. Now, it's quite a long list. There's about 250 carriers on the list. I'm only showing the top 3 alphabetically on here. But it is essential that longshore is placed with an approved carrier. And they're approved by the U.S. Department of Labor, not by any state regulator. Unfortunately, not always carriers know this. And we've got some carriers out there today issuing longshore coverage who are not technically approved to do so. If they fail to pay a claim, that could be a really nasty event. At minimum, you're going to be looking at them cancelling the coverage because the federal DOL will be back down on their case. But also, you're looking at maybe some penalties if they don't pay the claim. Have a look down the bottom here. It shows ACE American Insurance Company, for example. They're covered for the longshore, for the outer continental shelf, defense base, non-appropriated funds, and DC. DC, all employees, private employees in DC also fall under the Longshore Act, strangely enough. And they've been approved to write this business since October 1946. It's worth mentioning here that, as you see there, that's ACE American and underneath is ACE Fire. Groups are not approved by the whole group. They're approved by individual carrier. And again, this is where we can find some underwriters that may not be aware that one part of their group is approved and another one isn't. In fact, I got asked some years ago to try and help out a carrier who'd been issuing longshore policies in one part of a group, then suddenly issued them in another part, and that particular part wasn't approved. So if you have a longshore policy you're trying to place or want to place, do take a minute, check this list, and make sure it's with an approved carrier. This is the longshore endorsement that goes on the policy, and it applies to everybody except California. California, you've got your own one, but this applies to everybody else in the country. And if you write any longshore accounts today, and there's one thing you want to take away from the seminar, please let it be the next couple of minutes, because this is absolutely critical, not only to the correct placement of longshore, but to prevent E&O exposure. We write workers' comp policies all the time with, let's say, Florida in 3A, and then very simply in 3C we put all other states except monopolistic, or we list them. It's very easy to get other state coverage. Unfortunately, 3C doesn't flow through to longshore. The longshore endorsement, in its strange way, says this only covers accidents occurring in a state listed in the schedule. And the schedule is that schedule in the middle of the endorsement. You see mine here has got the state of Florida, and there's normally a percentage to the right-hand side. You can ignore the percentage, it doesn't mean anything. But this only provides longshore coverage in the state of Florida in my example. Well, if I've got somebody in Jacksonville, Florida, that runs across the border to Georgia for a day to do a job, if it's a state act job, then 3C is going to follow them. But if it's a longshore job, because you don't have Georgia in this state list, they have no coverage. This was actually brought to me by a student some time ago. They had an employee in Texas, and they had a Texas policy for them. They had a Florida policy for a subsidiary, and a worker went to Mississippi, did a longshore job for a day, and was declined by both policies. This is really a dangerous situation. Plus, there are very few carriers that will give you an all-states longshore policy. It's very, very tough to get. The first thing I do when I look at one of these is, do I at least have the same number of states on this endorsement as I do on 3A? So if I've got California, Nevada, Oregon on 3A, have I at least got those three on the longshore endorsement? Okay, except there's probably not too much longshore exposure in Nevada, but I still want to have it on there just on an in-case type of basis. I then got to ask the insurer, where could you work? Remember, the claim that was brought to me was a person working for one day in Mississippi. This is not permanent occupation. This is not setting up a branch. This is, where can I be? Marine employees tend to travel, particularly for those of you who are listening from the Gulf of Mexico. You know your employees are in Texas one day, Louisiana the next, Mississippi and Alabama the next two. And if you don't at minimum have those 4 states on the policy, you're leaving your E&O up for grabs, because at some point in time there's going to be an accident that's not happened. Please watch out for this. If you place longshore policies today, please check your endorsements. Make sure this is cured. If you don't carry longshore, the insurer could be fined up to $10,000 per claimant, or at least in theory by imprisonment, although we've never seen anybody put to jail for not carrying longshore. I think probably that the worst set of penalties, or the best persuasion you can use for a client, is the loss of corporate veil, where the employer is a corporation, the president, secretary, and treasurer of that corporation can be severally liable for such fine or imprisonment, and personally liable for compensation. This is a pretty hairy set of benefits. On top of that, not only do you have to pay the claim under longshore, but you then lose sole remedy, and you can be sued on top of this. Even if you have an if any exposure, this is the type of thing you need. One of the best tools, in my mind, where you can establish whether a particular risk is longshore or not, is the longshore factor. Now I'm probably a little biased as we designed it in this office, but we designed it on a defense mechanism, to be quite honest with you. We'd get so many questions and so many calls saying, is this person longshore? We built this website with some logic behind it that allows you to go through, answer typically 7 or 8 questions and get the opinion of the website as to whether this account is longshore or not, or this particular exposure is longshore or not. We do have some agents I know that use this with their clients. The only thing I recommend strongly if you do that is run through it first so you know what the answer is going to be before you get that. If you want to get a real legal opinion, obviously go hire an attorney. This isn't a legal opinion, but this is a common guide to longshore based on our many years of doing this type of insurance. Switching now from longshore, let's see if I can address just a couple of quick questions here that have come up. Is a private yacht club a marina? No, it would be considered under the club exclusion, which is the one above that. Further define a marina? Not really. There's nothing written on how to define a marina. Again, in conversations with the Department of Labor, they've told me that it's predominant income from storage of boats. That's the key. So it's not payroll here, this is income. So you're going to look at, say, what's your receipts? You make $1 million of receipts. Is it more than half coming from storage of boats? Then it's typically going to fit a definition of a marina. If it's more from repair, we'll get them in the boatyard exclusion, which comes down lower on. Definition of a commercial vessel, anything that makes money. Occasional charters are toughie, there's no answers on that. I'm not aware of any definition. If it's regular charter, certainly it's going to be considered a commercial vessel. If it's chartered once or twice a year to your friends, I haven't seen a case go that way, but again, I would not like to leave somebody without coverage, because without coverage, not only do you not have somebody to pay, but you don't have somebody to defend. Direction officer's policy question on the bottom. I don't have an answer to that. I'm not a D&O expert. I know within the community we have some, so we'll repost questions on directors and officers to see if they can be covered for the penalties leveled. I don't think it's a good way to do it. It's easier and cheaper to buy longshore, but I'll let one of our D&O experts talk about that. Let's move on to Admiralty coverage for a moment. This will be our right-hand column in our workers' compensation wall. And they took a case, the Supreme Court took a case in 1991 to set up the test of who gets Admiralty benefits. The worker must have an employment-related connection to a vessel in navigation and must contribute to the function of its vessel or to the accomplishment of its mission. Willander was a paint foreman. He worked on a paint barge, a paint boat, supervising the sandblasting and painting of an oil rig in the Persian Gulf. Persian Gulf, I just said. Persian Gulf is, what, like 10,000 miles from here. So suddenly our 12-mile limit has gone away. The 12-mile limit applies to longshore, but when we get into Admiralty, we can have claims anywhere in the world. The funny part, though, of Admiralty, and as a lot of people think that, oh, that only applies on the high seas, it's not true. It applies in all those same waters as longshore does. But this is the one for the vessel-based crew, the people that are on the boats rather than on the land working on the vessels. This works just as well in Lake Tahoe as it does in the Persian Gulf. Willander was supervising the painting and sandblasting of an oil rig, so he was clearly contributing to the function of his vessel, because the vessel for him was the paint boat. But we put a lot of different people on board boats today. On cruise lines in particular, we put entertainers, hairdressers, and all variety of different people. And all those people fall under this Admiralty law. Yes, it's easy to take the captain and the crew and the deckhands and the engineer. They always have been and always will be longshore. I'm sorry, always have been and always will be Admiralty. But we keep expanding it by putting other people on board boats. So a painter standing on a barge can get the same benefits as that captain of the ME2. So what type of benefits you get? You get maintenance and cure, unseaworthiness, wrongful death, you get our friends the Jones Act, and death on the High Seas Act. By the way, there is actually no such thing as the Jones Act. That's just its nickname. It's really called the Merchant Marine Act of 1920. And it was authored by Senator Jones, which is why it got its name. What can you get under all of these? Loss of past wages, loss of earnings capacity. And this is a tort base, so it's whatever you can convince the judge or the jury to give you. Loss of earnings capacity is quite fascinating because, of course, every young man that's injured ends up being captain of the QE2 in 5 years because this includes promotions. Past and future, lifetime medical expenses, pain, suffering, and loss of life enjoyments. You only get prejudgment interest in unseaworthiness and wrongful death. So how do we insure this? There's really two major ways of insuring this: maritime employer's liability and protection and indemnity. We use protection and indemnity where we put people on our own vessels. If we own a tugboat, we own a barge, we own a party boat, we own a ferry boat, our crew are covered by the P&I policy, the protection and indemnity policy. When we put our people on somebody else's vessel, we use maritime employer's liability. We can do this monoline, or we can do it by endorsing the work compensation. There are some problems with that. If you use a workers' compensation carrier to write MEL, the basic limit they can give you is $25,000. If you go to the assigned risk and state fund carriers, they typically can only give you $25,000. But many voluntary carriers can increase that $25,000 up. We get a lot of policies being sent to us by agents around the country and say, oh, I've got $1 million of MEL. Show me the policy. Well, they send us the deck page, and the deck page shows $1 million of EL, but when you dive back down into the maritime employer's liability endorsement close to the back, often that only has a $25,000 limit on it. $25,000 is not enough money. It's not even a limit, it's a deductible. You can't say hello in federal court for $25,000. You can buy excess limits. First of all, some carriers will allow you to increase it. That's fine if you can do that. But you can also go out and buy excess policies. Typically $975 over $25,000 is the most common, and Lloyd's writes a lot of those, although some domestic markets are coming in the right as well. But we've got a problem by doing that. The NCCI endorsement only covers injuries within the continental United States, Alaska, Hawaii, Canada, and those operations involving a vessel sailing directly between ports. So the maritime employer's liability applies up to that same 12-mile limit as longshore. Well, for most of the employees that have this MEL, they can probably get longshore benefits within the 12 miles. But if they go beyond the 12 miles, they stop being able to get longshore benefits, and only have maritime employer's liability to fall back on. But at that moment of time, the NCCI endorsement stops covering them. Again, if you're involved in the cruise ship market or maybe the oil market, you're going to have people going to the Caribbean, maybe to Mexico, maybe all over the world. And if you're using an NCCI type MEL endorsement to cover them, you're going to be in trouble because it's not going to cover them beyond the continental United States, Alaska, Hawaii, or Canada. Worse, if your $25,000 sub-limit is there and has this limitation, it doesn't matter how much excess limit you put on top of it, you still had that same limitation. It's a real problem. Watch out for crew exclusions on P&I policies. They're creeping in now a little bit more than they have done in the past. I'm not a fan of them. If you own vessels, you really need to insure your own crew. But if you do decide not to, you want to go and insure them some other method, watch out for this wording, in particular the part in red at the bottom here that's creeping in. or to any employees of contractors or subcontractors. You may only can insure your own crew elsewhere. It's unlikely you're going to have any control of insuring the employees of contractors or subcontractors. Come back and answer some questions in just a moment. Let's run through these links for you in a moment. Longshore Toolbox is the site where you'll find the Longshore Factor as well. That's got a lot of references and information on Longshore Toolbox, including that factor. There's a blog, which is blog.ligmarine.com, which is the Longshore blog. Some news sites there. Then the federally approved longshore authorized carriers and self-insured employers. That's the really critical list you have that you need to use to make sure that you have the right carriers on this risk. Let's come back and try and deal with a few of these questions now. Can I explain the difference between P&I and maritime employer's liability again? Yes, simplistically, P&I is my own vessels. I own a tug, I own a barge, I own a ferry boat. I'm going to have P&I. That's for my people on my vessels. Maritime employer's liability is a way to cover the same type of exposures for my employees, but I'm putting them on somebody else's vessel. So maybe I'm a caterer putting people on board a ferry boat or a party boat. Maybe I'm an entertainer, I put people on board cruise ships. Use maritime employer's liability of that. If U.S. LNH is only incidental, you must still have coverage. Yes, the incidental, there is no definition of incidental in the Longshore Act either. Either you have coverage or you do not have coverages. I've got a question about a railroad employee. That one I think we'll deal with offline. It's not, I think, one for the main group, but the person that sent me that, if they'd like to send it to me by email, my email address is on the front of that, and we'll deal with that offline. If anybody's got anybody other questions? I don't see any more questions popping up. Okay. All right, so we go back.
I'd just like to say a few things here, and then as people write their questions in, there might be a few more as we go. Thank you all for joining us. It is just about the top of the hour again, and so if we have other questions about the Insurance Community Center, University, or for Ian and about his company, feel free to write those in, and we'll answer those for you. And any remaining questions, I'll provide you with some contact information for Ian and myself. Again, this recording is going to be available for you within 24 hours online, and please feel free to access it. You'll receive an email from me with the link to access that. When you do log off, you will be directed to a survey. If you could answer it, the short survey just has to do with today's presentation and what you're looking for out of the Insurance Community Center. So with that, Ian,
I've got a bunch of questions popped up. I'll answer some of those if anybody wants to stay on and do that. Why are P&I carriers excluding the insured's employees when that's one of the purposes of purchasing P&I? Usually it's a choice of the insured. They don't want to pay the premium. Paying for crew coverage can be very expensive. Again, it's a choice. Some carriers will do it just because they don't want the risk, but more it's a case of the insured making that choice. Again, making that choice I don't think is a good idea, but nevertheless I think you should be very aware of what that exclusion should say. Accepting exclusion for your own crew is one thing, accepting that exclusion for the contractors and subcontractors is even worse. Program of working control room, a cruise liner, if it's at dock, they would not need admiralty coverage. If it's in sailing at all, if it's whether it's within U.S. waters or outside, absolutely will need admiralty coverage. Any job on board the vessel will do that. We have a land-based contractor building a wharf, hires a sub to do the pile driving. If the sub doesn't carry longshore, does it fall on the general contractor? Really complicated answer to that, yes. We have a clerical worker for a shipping office agency who works primarily in office. However, when they ship arrives, they go and greet the captain. The check manifest. This happens 3 to 4 times a year. Would they need to be covered under longshore? Yes, that's identical to my situation with the bookkeeper. She didn't even get onto the dock and she needed longshore benefits, or she got longshore benefits. My client's a marine contractor and lets his crew go work on another marine contractor's vessels. Will my client's MEL from his P&I coverage, or do I need a separate MEL policy? There is no MEL within a P&I. They're different coverages. The P&I covers you only on your own vessel, so you would need an MEL policy. Some underwriters will add it to the P&I by endorsement, but most commonly it would have to be done as a monoline policy. What about volunteers who are divers for a dive and rescue corporation? Does the fact they're volunteers exempt them from workers' comp? Longshore has no volunteer exclusion, but you do have to have an employment connection. So they have to receive something in exchange. It could be as little as food, believe it or not. If we feed them for working, or we do something like that, that's enough to be compensation. Volunteers are really tough in the marine market because you don't really have an income level to charge them. But there is no volunteer exclusion under the Longshore Act. A couple more questions. Did Stewart versus Dutra change the game? Jay Coop's referring here to a case on the big dig out of Boston where a person working on a dredge was held to be a Jones Act seaman. I don't think so. I always believe they were Jones Act in the first place. I don't think this changed too much. Security guard at a freight forwarder's terminal underwater is longshore, absolutely. Unless you lock them in the office, that's the only way to keep them in. Susan Erickson asked me to address excluded officers. There are no exclusions for officers in longshore. If the officer does any longshore work, they have to be covered for it. You can apply the normal payroll limitations for an officer, but they do need coverage. Does a contractor working on a dock or a wharf need longshore coverage? Generally, yes, unless you can show that the job is totally not related to marine. We had a roofing contractor, for example, that was roofing an office building. They were taken out of longshore, but that's a very rare example. If they've been roofing the marina building, if they've been roofing the ship repair building, they would have been longshore. Oh, Tron, come on. Tron, agricultural worker on a salmon farm in Puget Sound. They load feed from vessels to the pens. Washington workers' comp on longshore. Have to look at the geography of that. If they are a pen fenced-in area, they would be considered out of longshore. Unfortunately, your Washington work comp may also think they're out of that, so you may have a little bit of an argument there. We can cover them under longshore if we need to do so. Yacht club launch driver subject to longshore? No. If it's a private club, a member-type club, they would be excluded from longshore, but they would be Admiralty employees. They're driving the vessel. And again, Yacht Club Sailing School offering sailing lessons, the same answer to that one. Again, I hope I've had a chance to answer most of your questions. If I haven't, you can see my email address on the top of that. Happy to answer any other questions by email. And thank you for your time this afternoon. Goodbye.
Thank you very much. Thank you very much, Ian. Everyone else, thank you for joining us, and have a great afternoon.
The organizer